Welcome, and thank you for joining us today. My name is Sandra Guarascio, and I'm a partner at Greyell. With me today, I have my partner also at Greyell, James Pondopoulos, and Richard Hart, who is a principal of ProActive Resolutions, which is a unique company that we're pleased to partner with on this and other initiatives. So today we're presenting on the topic of demystifying workgroup conflict, a legal and practical framework for understanding and responding. You will see that with this interface, it allows for questions to be typed in. We'll do our best to address your questions as they come. We're unable to do that. And if not, we welcome you to contact any of us after the presentation as well. So what we will be covering in this presentation, we'll talk about the legal regime that exists around these issues. We'll talk about employer responsibilities and action, including proactive steps that employers can take. And we'll talk about informal and consent-based processes that address these issues, formal investigations, and then investigation outcomes. So clearly, from that perspective, it is important to consider your legal risks in the actions taken in response to workplace conflict. We will identify factors throughout our presentation that are important in establishing a due diligence defense, which is the only defense that you have if you ever end up in an adjudicated setting. Overall, our goal is to help you understand the legal obligations in the context of workplaces and how to meet those legal obligations in a way that also helps you to better manage your business interests. So in terms of the legal regime, these are the areas that we'll be covering: human rights, arbitration, WorkSafe BC, civil actions, criminal. There are some overlap in these areas and the analysis that applies.
Sandra, hello everybody. My name is Richard Hart. I just wanted to jump in there with a quick point, which is that you mentioned due diligence defense. And I think it's important to note that while due diligence and risk management are really, really important in organizations, you can't manage an organization by focusing exclusively or even primarily on due diligence defenses or risk. At the end of the day, the organization does not exist in order to manage its risks or in order to create a due diligence defense. The organization exists in order to meet its mission, vision, values, and strategic objectives. In that regard, what we need to do is to make sure that the organization is focused on those big picture items. Best practices suggest that the organization should create a comprehensive behavior management program that drives the critical behaviors, the behaviors that add to the capacity to deliver on mission, vision, values, strategic objectives. By doing that, by pursuing excellence in that way, we'll be able to address, as a corollary outcome, the due diligence defense. So just the suggestion as we're listening to this, to keep that in mind. And in that regard, it may be worthwhile to consider that there are actually a range of behaviors that could be considered high-cost behaviors. This latter is a way of prioritizing the different categories that can be used to organize the behaviors in workplace that can represent risk. We're well aware of the ones at the top that are perhaps prohibited by criminal laws, and ones in the middle that, at least in certain circumstances, are prohibited in relation to human rights legislation, or the ones at the bottom, which some people would lump together in the nomenclature of incivility. Those can be just as high a cost to an organization. Different costs, maybe not imposing criminal liability, etc., but just as high a cost in terms of the outcomes of mission, vision, value, and strategic objectives. So important to keep in mind the full range of problematic behaviors, high-cost behaviors in a workplace. One
of the things that I really like about the ladder that Richard has introduced is as well is it demonstrates how conduct may start at the bottom, but that it can easily escalate up the ladder. So that's something that we always encourage people to be watching for. So diving into the legal regimes around this, we'll start with human rights and harassment and discrimination in that context. Human rights legislation sets out obligations under the Human Rights Code that apply to various arenas. And for our purposes, the important ones are employment and the provision of services, as many of you are service providers. So the legislation addresses prohibited grounds of discrimination, and sometimes workplace conduct will engage human rights legislation. And that opens up possible claims under this legislation to the BC Human Rights Tribunal under the BC Code, or for federal employers, complaints directly to the Canadian Human Rights Commission or the Canadian Human Rights Tribunal. There are several components to the legal test that applies in the human rights context. We will go through each of these so that you can better spot circumstances where you may be dealing with a human rights issue. What's at stake with human rights issues? There's a potential for higher damages awards, and you're also engaging legislation that's designed to protect dignity interests. And from an advocacy perspective, that is treacherous, adjudicated territory. So the first branch of this test addresses conduct, comments, or gestures. And here you're looking at a very broad definition of what might fall into this realm. And we ask you to consider any unhelpful conduct. So remarks or jokes based on stereotypes, comments or gestures that have to do with the prohibited ground of discrimination, sex, race, gender, sexual orientation. Sometimes it's physical contact, and it can be active or passive. Again, you want to be looking at a big tent definition in terms of conduct that may fall within what might spark your concern. The second branch is that it's actually based on prohibited grounds of discrimination. Now, these are the grounds that are set out in Section 13 of the BC Code. The ones that we see most of in relation to workplace conflict, probably race, religion, sex, sexual orientation, physical disability, and mental disability. Often we see circumstances where more than one of these grounds is engaged as well. The next part of the test is whether the conduct is unwelcome or reasonably should be known to be unwelcome. Sometimes a person says stop. They're very clear about it. And frankly, we're lucky when someone puts their hand up and says stop. It's a very clear indication that the conduct is unwelcome and unhelpful in the workplace. But express rejection is not necessary. And silence does not necessarily mean that it's okay, particularly if you're in a circumstance where there's a power difference and the respondent has more power than the person who is receiving the unwelcome conduct. The test that's applied is the reasonable victim test. That's how the law looks at it, is through the eyes of the reasonable victim. What would a reasonable person in these circumstances think is welcome or not? And the final branch is whether there's detrimental effect. There's a subjective component to that analysis, how the conduct is affecting the victim subjectively. Does it impact their sense of dignity in the workplace, their ability to fit in within the group? Does it poison the work environment for them? Objectively, what you're looking at here are job-related consequences. Is there a reduced chance for promotion into a desired position because of the conduct? Is there an inability to attend work without impact on mental health? Is the performance of the work impacted or impeded? Now, this is a human rights case that illustrates the analysis of these human rights factors in the context of workplace conflict. These were very sad facts. Mr. Garneau was a long service employee of 14 years in a grocery store environment. He was earning minimum wage. He had a disability that had both physical and mental impacts. He had been diagnosed late in life with dysogenesis of the corpus callosum. That's a burnt defect where the two hemispheres of the brain are fused instead of being separate. It impacts his physical appearance and his weight. He was a very large man. It also impacted some of his mental function. He He was also gay, and although he was not open about his sexuality, his employers perceived him to be gay. Now, he was subjected to homophobic name-calling and really derogatory comments about his mental abilities and his appearance. It was immature name-calling. And it was his supervisors who were saying these things to him. They were the sons of the owner. This was a small family-held business. It occurred in front of other employees and in front of customers, and there was malice in the name-calling. He testified in the tribunal case that it made him feel less than human. He was constantly being asked whether he was gay. It was a parroting, pestering way. He was physically assaulted on 2 occasions where he had been pushed down. His bicycle was borrowed without permission. The seat was twisted. His smartphone was stolen and found in one of the supervisor's possessions. He had actually filed a WorkSafe complaint, and the prevention division had responded. They made orders. There was no compliance. His work hours were also reduced, and eventually he resigned from his position. What the tribunal said about these circumstances was that while the adverse treatment towards Mr. Garneau arose mainly because he was seen as weak and vulnerable, his disabilities and his sexual orientation that was perceived by the employer were factors. Now, at this tribunal hearing, the respondents didn't even appear, so the evidence of Mr. Garneau was uncontradicted, and he represented himself. The members said of him, Mr. Garneau testified in an open and frank manner. When he could not remember dates or recall certain events, he said so. I found him to be an articulate, thoughtful, and credible witness. An important takeaway from this case as well is that the perceived possession of a protected characteristic is protected under the code. That was reiterated in this case. So whether or not Mr. Garneau was gay, it's enough that he was perceived to be. So in terms of the order that was made by the tribunal, if you look at it in the context of the 4 factors that we looked at, there was unhelpful conduct. There were human rights grounds related to that unhelpful conduct. It was clearly unwelcomed by Mr. Garneau, and it resulted in adverse consequences for him. The tribunal awarded him with $15,000 of injury to dignity, feelings, and self-respect damages. And those are specifically provided for under the legislation, this ability to award an amount for injury to dignity. There were very minimal wage loss awarded in this case, and that's because the reduction in hours was found not to be related to his disabilities or discrimination. It was due to a genuine downturn in the business. Mr. Garneau did, however, seek in this case compensation for loss of his home and his car, because when he was no longer able to work, he was unable to meet his financial needs. And what the tribunal said about those losses was that I accept that the loss of employment contributed to his financial difficulties, but they couldn't conclude that those consequences flowed directly from the discrimination. That's important to understand because if there had been evidence of that nature, human rights legislation has broad remedial power, and the ideal is to make people whole. So here they weren't able to establish the evidentiary link, but in cases where you can, the damages awarded by a tribunal can be substantial. Now, in relation to dignity, feelings, and self-respect awards, there are some examples of them listed here where they've gone up to roughly around the $35,000 mark, and we see a trend of those damage awards increasing. In the UPC versus Kelly decision, this went to judicial review, and the Supreme Court overturned what had been awarded by the tribunal as a $75,000 award for injury to dignity. And they found there that the circumstances were not unique, such that an award of double the previous high water mark should be awarded. Now, Dr. Kelly, in this case, was a student in the Faculty of Medicine who required accommodation of his disability. He had ADHD and nonverbal learning disorders. Some steps were taken to accommodate him, but eventually he was dismissed from the Faculty of Medicine program due to lack of suitability. The issue was around, in the case, was around the principles to support damages for injury to dignity. And the tribunal's decision to award $75,000 was found not to be based on principle. It was found to be discretionary and arbitrary. And so this was the BC Supreme Court stepping in to say, hold back, tribunal members. And that's important to know that there's this dispute playing out with decision makers on this, because as I said before, human rights legislation can be treacherous adjudicative territory because it is designed to assist complainants who make out their case. I'm going to turn it over now to James to discuss how workplace conflict is addressed in the arbitral setting.
Hello, everybody, and thank you for joining us today. James Kondopoulos. I am here at Workgroup. I will discuss some of the key arbitral cases. These are important cases because they laid the groundwork for a lot of what we now see happening in the law, and frankly drove some of the approaches we now see codified in the workers' compensation legislation. Now, we know that labor arbitrators have the jurisdiction to deal with human rights legislation, other employment-related legislation, on the theory that the substantive rights and obligations found in those pieces of legislation are implicitly incorporated into every collective agreement. And the Supreme Court of Canada told us that in Perry Sound, a case from 2003. Now, one of the key cases in the arbitration case law, bear with me a second here as I move through the slides. Sorry, I'm having a little bit of difficulty moving through the slide. All right, there we go, back in order. I am a bit of a Luddite, so forgive me, and I'm pleased we overcame that technical challenge quickly. One of the key early cases dealing with workplace harassment was this Toronto Transit Commission decision of arbitrator Scheim. And there are some fairly strong statements contained in this case, statements which have proven to be foundational and seminal statements. Arbitrator Scheim explained that abusive conduct includes physical or mental maltreatment and the improper use of power. It also includes a departure from reasonable conduct. So pause there and note that these are expansive definitions. Note the arbitrator's use of the word includes. We then have the idea of the conduct, the alleged offensive conduct being measured on an objective standard. The idea is that there is heedless disregard for the rights of another person, and conduct which demonstrates the aggressor should have known better. Now, useful language from this BC government case from 1995, an early decision in this area. Harassment and frankly bullying are serious words to be used seriously and applied vigorously when the occasion warrants its use. And a caution there about overuse of the word, or frivolous or vexatious use of the word. Now back to Mr. Scheim's decision in Toronto Transit Commission. Again, note the use of the word includes. Harassment includes words, gestures, and actions which tend to annoy, harm, abuse, torment, pester, persecute, bother, and embarrass another person. Now, I was one of two siblings who were close in age, and I can tell you that almost all of our behavior was captured by those words. But keep reading that definition, as well as subjecting someone to vexatious attacks, questions, demands, or other unpleasantries. So a really broad definition. Again, we fall back on the objective test, and we go to this decision in Kara Operations from 2005, a marked departure from reasonable conduct. So again, we're trying to measure it against a reasonable standard and objective standard. We have a statement from Mr. Blazina. He was a labor arbitrator at the time, now a member at the BC Human Rights Tribunal. Even a single incident can amount to harassment. There is an idea that harassment is generally a course of conduct. But this arbitrator, and arbitrators after him, have made it clear that a single incident can amount to harassment if it is sufficiently serious or egregious in nature. This case out of Nova Scotia from 2007 issues the following caution. Sexualized and racialized words and conduct are not appropriate. Here's the caution. What one person hears as banter can be perceived by another as outright discrimination. So the old story of boys will be boys, or that's happening on a shop floor, so what, is not good enough. We're measuring against the standard of reasonableness. Context is important, and all of the circumstances, including individual circumstances of the affected employee, are important. Now, this decision is an important one, and what we see happening here is ultimately embodied in the workers' compensation regime, which Sandra will speak to in a few minutes. In this case involving Shoppers Drug Mart and a harassment grievance filed on behalf of a UFCW employee, there is an incident arising out of an extended coffee break. One of the managers in the Shoppers store confronts an employee in a public place, the slide says, but really in front of customers. And the issue was what the manager believed to be an extended coffee break. The employee responds by claiming harassment. Jumps to that card of harassment, and remember those words from that BC government case about not jumping too readily to that allegation. The arbitrator finds in the course of his decision that the investigation of the employer was flawed, but makes several important observations. We see the same observation as the one Mr. Blazina made. Mr. Larson says here that even a single incident can be harassment if sufficiently egregious. But here is a key statement contained in the case, a reminder to us. Not every employment bruise should be treated under the harassment process. It would be unfortunate if the harassment process was used to vent feelings of minor discontent or general unhappiness with life in the workplace, so as to trivialize those cases where substantial workplace abuses have occurred. And here are the key concepts that we see in the legislation sometime later. Even severe criticism is not harassment if it is a genuine or bona fide attempt to deal with the performance problem. So here we have confirmation that managers and supervisors can manage or supervise, provided they're behaving in a genuine, bona fide, legitimate business way. Even harsh conduct, if it is bona fide performance management, will be acceptable, Mr. Larson said in this case. And frankly, as that theme has emerged time and time again in the case law and in the workers' compensation regime. The arbitrator did find the behavior of the supervisor or manager to be rude, impertinent, and impulsive in this case, but declared that the incident was not harassment. Now, the new frontier. And we've talked about expansive definitions of what can give rise to harassment and bullying. we now see these concepts being applied in the cyber arena. So here's a case from 2012 involving Canada Post. A postal clerk with 31 years of service was fired after management became aware of postings she had made to her Facebook account. Now, those postings were made over a 1-month period, presumably involved postings which were made outside of work hours, off the work site. Now, there were a number of derogatory statements in which the clerk mocked her supervisors and the employer. She said some really negative things about Canada Post. And here's some of what was posted. And this is Arbitrator Punek summarizing what was posted. Universally nasty in tone and content. Majority aimed at superintendent. Vulgar, contemptuous terms, including bitch, wicked bitch, evil hag, and devil. This is strong language, which is now appearing on a Facebook page. And for extra emphasis, the griever capitalized. She made notes about, well, she abused, she intimidated, she mocked, and the arbitrator said that she was, in effect, inviting others to join in and offer their own mocking comments. Here's the conclusion of the arbitrator. Mean, nasty, and highly personal postings go well beyond general criticism of management. So we see recognition here that some degree of criticism may be acceptable, but targeting one person with a degree of venom unmatched in other cases was simply not on. Repeated mockery, threatening language, vile insults, debasement of an identifiable manager. And all of that, the arbitrator concluded, was sufficient to ground a case of cyberbullying or cyber harassment.
So as James said, WorkSafe BC has now stepped up, rolled up its sleeve, and it's codified some of these broader principles that primarily came out of arbitration law. There used to be this gap. If the contract didn't quite meet the threshold that is required under human rights legislation, such that it didn't engage a prohibited ground, and you weren't in a unionized environment, there was really very little remedy for conflict in the workplace, respect in the workplace issues. WorkSafe has filled that gap now. So under the Workers' Compensation Act, there are general duties set out for employers, workers, and supervisors. And those general duties include ensuring and protecting health and safety. And now they specifically include health and safety, within health and safety, this broader notion, workplace bullying and harassment. And this comes through the different divisions of WorkSafe. So under the claims division, claims for compensation due to bullying and harassment are now possible, just like you would be able to make a claim for a broken arm. And that's under Section 5.1 of the Act. And through the prevention division, there are now occupational health and safety policies on workplace bullying and harassment that came in effect on November 1, 2013. Those policies outline very specific steps that have to be taken to prevent and address issues of workplace harassment. So through the claims division, you have to establish that you have an injury to make a claim. Claims for mental disorders under Section 5.1 are now possible, and a worker may be entitled to compensation only if the mental disorder is a reaction to one or more traumatic events arising out of and in the course of a worker's employment. And secondly, if it's predominantly caused by a significant work-related stressor or a cumulative series of significant work-related stressors. And this is the magic language in the legislation, including bullying and harassment, arising out of and in the course of a worker's employment. So this blew the definition wide open in terms of what could now be a compensable claim and issues that employers had to be alive to in workplaces. Now, the mental disorder has to be diagnosed by a psychiatrist or a psychologist for the claim to be granted, and it can't be caused by an employer's decision relating to employment. So that means that it won't be eligible for compensation if it's triggered by the fact that there's been a change in work or working conditions, discipline, termination of employment, workload and deadlines, work evaluation, performance management, etc. These are all workplace decisions that are necessary for managers to be able to operate their businesses. So turning now to the occupational health and safety requirements, these sections of the legislation refer to specific employer, supervisor, and worker obligations about workplace bullying and harassment. There are also additional policies that place more responsibility on all of the parties, and they require that employers develop policies, specific harassment and bullying policies in the workplace, that they take proactive steps to prevent or minimize bullying and harassment, that they develop and implement procedures for the reporting of incidents or complaints, and for investigations. They also have an obligation now to train workers and supervisors on those policies and procedures. So this is very detailed, mandatory direction that's been issued by WorkSafe in respect of these points. So under this scheme, an employee can file a workplace bullying and harassment complaint with WorkSafe BC that is separate from a claim for a mental disorder. And WorkSafe BC will then make inquiries to ensure that the parties in the workplace are fulfilling their obligations. This is what happened in the case that we discussed when Mr. Garneau had complained. WorkSafe responded and issued orders. Specific disputes or complaints in the workplace are resolved between the employer and the worker in accordance with the employer's policies. So WorkSafe will come in, assess whether you have the right policies, training, etc. in place, and then look for matters to be resolved in keeping with the policies. Employers will get directives from WorkSafe, and WorkSafe conducts what's essentially an investigation that can, in some circumstances, be very cursory, but can wind up with a decision being issued to an employee that could have implications for your place of employment, particularly if you don't agree with the decision that was made by WorkSafe. So looking at the policies of WorkSafe, it's considered an occupational hazard. That's how workplace bullying and harassment is now treated. And they specifically define it as any inappropriate conduct or comment by a person towards a worker that the person knew or reasonably should have known would cause that worker to be humiliated or intimidated. So you can see in that definition some of the comments out of arbitrations that James had reviewed, some of the language that's used in the human rights analysis being pulled together in how WorkSafe addresses these issues. They also specify that it can be in relation to a single event, but most often it is a pattern of conduct that they're looking for. The definition provided by WorkSafe BC also specifies what is not workplace bullying and harassment. It does not include reasonable action taken by an employer or supervisor relating to the management and direction of workers or the place of employment. And here are some of the examples that might be raised as that to fall within that exception. So this is recognition that managers and supervisors have many important responsibilities, and that by virtue of their role, they're put into this position of potential friction in the workplace, involved with the direction and supervision of how work is performed, providing feedback, etc. As long as the actions that they take in meeting those obligations of their own in the workplace, as long as they do that in a respectful manner, then it's not going to constitute bullying and harassment. We are, however, seeing a lot of complaints by employees that take issue with the manner in which reasonable management actions are taken such that they're no longer reasonable. Also excluded from the definition of what is bullying and harassment, expressing a mere difference of opinion, offering constructive feedback or advice about work-related behavior or performance. and making a legitimate complaint through established procedures about a manager or another worker's conduct. None of that can constitute bullying or harassment. So what is it? What are we looking at? It includes any inappropriate conduct or comment towards a worker that a person knew or should have known would cause that worker to be humiliated or intimidated. And some examples might include verbal aggression, insults, or calling someone derogatory names, vandalizing a worker's personal belongings, sabotaging another person's work, spreading of malicious rumors, carrying out harmful or offensive initiation practices or hazing in a workplace, making personal attacks based on a worker's private life or personal traits, and making aggressive or threatening gestures. Now, cyberbullying, which James raised in a more recent cutting-edge example, is another form of bullying and harassment. It can include sending harassing emails or text messages, or posting humiliating or intimidating information on social media or websites. Now, bullying can come from many sources, including coworkers, supervisors, and employers, or from external sources, such as clients, customers, members of the public, or workers from other organizations. Each situation has to be considered in context. So, for example, if you're yelling at someone to warn them about a hazard, that might be appropriate given the situation. But calling someone demeaning names in front of clients or workers, it's probably not. So in addition, it's important to recognize that covert actions can also constitute bullying and harassment. And think back to the conflict ladder that Richard had introduced us to. Some of those more uncivil types of conduct that were towards the bottom of the ladder might fall into that category, isolating people in the workplace, ignoring them, manipulating circumstances to their detriment, even though they might not initially know about it. Those are the types of behaviors that can constitute bullying and harassment, and significantly, if left unchecked, can escalate into something far more serious in your workplace.
Sandra, thanks again for raising the conflict ladder. I think what this allows us to do is to come back, pull the lens back a little bit more, and to say, absolutely, it's helpful for employers, it's necessary for employers to understand the scope of their legal obligations, the legal framework. We can't get too caught up in the legalities of things. If we're overly concerned with legal questions such as, is this bullying, is this harassment, we're going to miss the bigger picture here, which is, what are the behaviors that are actually impacting our ability to deliver on mission, vision, values, strategic objectives? It's really helpful to know that at any given point, people may come to you expressing the concern that particular words and actions are constituting bullying, that somebody is a bully, that there's a harasser, that behaviors are harassment. What's fundamentally critical at the level, particularly of frontline managers, is that there be a capacity to understand the distinction between the observables, the words and actions, and the diagnosis, the label, the categorization that may be attributable to words and actions in a particular instance. Rolling of eyes in a meeting in certain contexts may be called bullying, harassment by somebody. Somebody else may deny that that's bullying and harassment. The critical question from an organization's point is this helping or is this interfering with our ability to deliver on mission, vision, values, strategic objectives in the context of this instance? So best practices for an organization require that we focus our frontline managers, supervisors, our individual employees on their accountability to be able to name words and actions that are impacting them, their team, their work groups, and that they be able to engage well with each other around the words and actions that are problematic without having to rely on labels such as bullying and harassment to do so. I'll transition back over to you.
I absolutely agree that our advice is to intervene early and often if it's necessary to do so. And it's in keeping with that adage that the best defense is a strong offense. Bullying and harassment is clearly a health and safety issue, and it has many effects. It can distract someone while they're performing tasks that require concentration, which can lead to physical injury, and it can also lead to physical illness and psychological injuries such as anxiety, depression, etc. Now, in the workplace, you might notice things that can trigger a concern that something more is going on. You might notice lower productivity, lower employee morale, higher rates of unexpected absenteeism, and staff turnover. An interesting thing about staff turnover is that studies show that bullying affects coworkers as well as the target, and that coworkers are as likely or even more likely than the target to leave their jobs if they work in a bullying environment. Now, this case, which I won't go through but wanted you to have for reference, is an example of a WorkSafe claim arising out of workplace conflict. And this was a claim for compensation that initially had been declined by WorkSafe and on review, and then was accepted by WCAT. And significantly, just to cut to the chase of the conduct that was involved there was what was described as a dressing down by a supervisor of this employee who made the compensation claim. And that dressing down involved the supervisor closing the door, yelling at her, calling her a something problem. The supervisor was verbally abusive, ugly with her words. She didn't allow the worker to speak. The worker was shocked. She was crying in the car on her way home. That was the evidence. She couldn't stop crying for 24 hours. She was ultimately diagnosed with PTSD and attended counseling and was off work for 6 weeks as a result of this. And so ultimately, though it went through several levels of appeal, this was found to be a compensable claim. I will now pass it over to James.
All right. One of the questions which has come up as Richard and Sandra have been speaking is, what obligation do employers have to identify a person as a risk? Now, an employer cannot stand by and be willfully blind to negative interactions, negative, offensive, unlawful interactions happening in its workplace. The law is clear about that. The law in the human rights area is clear about that. In the WorkSafe BC area is clear about that. The cases talk about the need for an employer to exercise due diligence, and we will speak more about that in due course. But at its core, an employer cannot stand by idly and let wrongful actions take place in its workplace. Now, this is a neat segue into my section in the presentation. I spend a lot of time dealing with civil litigation, with employment law claims, non-union context claims. So actions by individuals brought against employers in court. And there is this idea of an employee being able to bring a constructive dismissal claim against an employer, and the idea that the employee can claim extended measures of damages, moral, aggravated, and/or punitive damages, where conduct tantamount to constructive dismissal has occurred in the workplace. And let me talk about what I mean by that. There is a fundamental implied term in any employment contract that the employer will treat the employee with civility, decency, respect, and dignity, and will provide an appropriate work environment. Back to the question which was posed by one of the attendees. What is an employer to do where somebody has been identified as a risk? And here is part of the answer to that question. There is this fundamental implied term of of a healthy, safe workplace and the obligation of an employer to ensure that that is in fact happening. Now, an employee can turn around and treat the employment contract as at an end, where the employer permits the employee to be bullied or harassed or does nothing to address a poisoned work environment. These cases have predominantly come out of Ontario, but I submit are persuasive in BC. The reasoning is sound, and many of the same considerations would apply in BC, but for the following. In BC, of course, we have this workplace, this WorkSafe BC regime, which requires employees to claim, to pursue these mental disorder claims before WorkSafe BC. So there may be a jurisdictional basis for an employer to say, hey, we don't belong in court. You have no right to bring a civil action in court. You should be pursuing this before the claim division of WorkSafe BC. Now, all of that said, there is a gray area here, and these Ontario cases are useful to know about, and frankly could well apply in BC as well. So the first case I'd like to discuss is this Ontario Superior Court of Justice case, Levinskas and Whitford, 2005 case. In that case, the manager informed the plaintiff employee on an informal basis that he was not well liked at corporate head office. Question why information like that was passed by the manager to the plaintiff, but that's beside the point. The plaintiff started to become marginalized, and the plaintiff's co-workers were given the impression he was demoted. The plaintiff became depressed, took a leave of absence, applied for short-term disability benefits, but was denied, and an appeal from that decision was also denied. The plaintiff sued and claimed constructive dismissal. The employer took the position, he resigned from employment. So you pulled the trigger, you alleged constructive dismissal, there was no constructive dismissal, you, employee, in effect, walked away from your job. The court disagreed with the employer. The court found that the events appeared on their face to be innocuous, particularly when considered individually, but they had a deleterious effect when considered cumulatively and contextually. The court found the employee had in fact been constructively dismissed, but didn't go on to find intentional infliction of mental suffering or award punitive damages. Here is something the court had to say. Entitled to take reasonable steps to identify the shortcomings of the employee. I mean, that's a legitimate employer right. And to seek changes in performance. Again, a legitimate employer right. But the problem arose when there were steps taken to marginalize, reduce the employee's confidence, undermine his effectiveness. The court went on to say, was made to feel like he was not valued or respected as a result of his personality and style. There was little he could do to gain respect and approval of his superiors. Here's the point about the events considered contextually, cumulatively gave rise to a constructive dismissal. The court looked at the facts objectively and held that it was not reasonable to expect an employee faced with these adverse circumstances to persevere in employment. Another Ontario case. That's just a summary of what the case was about. I'd like to go into the facts. Plaintiff was a valued employee with considerable responsibility. Employer hired a family member who had a, quote, dramatic effect on the workplace. In the decision, we learned that this new hire had an explosive personality and was at times irrational did not listen and did not take direction well. People had to walk on eggshells when dealing with him. He appeared to have particular difficulty dealing with women. Now, the plaintiff brought this up with the employer, who dismissed the concern of the plaintiff as owing to the new hire's background. Her blood pressure went up. She had to take time off work. She chose ultimately not to return to work. The employer gave evidence that it was happy about the disruptive effect because it made the workplace more serious, more formal, and more professional. So, not an appropriate way to deal with someone who's been identified as a risk. Again, going to the question from our audience member. Now, here are some statements of the law in this area. Not only is an employer obliged not to treat an employee in a manner that renders competent work performance impossible or continued employment intolerable, an employer has a broader responsibility to ensure the work environment does not otherwise become so hostile, embarrassing, or forbidding as to have the same effect. Here's some other points. I've covered some of these already. Owes a duty to treat employees with civility, decency, respect, and dignity, provide an appropriate work environment. Remember, in this case, the problem arose out of a co-worker's behavior. So it wasn't necessarily coming from the employer itself, it was coming from a co-worker. But again, there was this obligation, common law, view of the court, to maintain a healthy, safe work environment. The court said there may be liability for damages for constructive dismissal and extended measures damages if employees are subjected to treatment that renders performance of work impossible or continued employment intolerable. The theory of it is there's a repudiation of the employment contract where there is that level, that degree of improper treatment. And the employee then accepts the repudiation, treats the employment contract as at an end, and recovers at least damages in lieu of notice. Ms. Stamos ended up being awarded 6 months of pay in lieu of notice, or damages equivalent to that. She was also awarded $6,100 as compensation for mental distress and as compensation for some dental expenditures she had incurred post-construction dismissal. This Walmart Canada case, 2014, is an important one. It came from the Ontario Court of Appeal. I'm not going to spend too much time dealing with it. I provided it to you for the sake of completeness. But again, it goes to this idea of an implied term, a fundamental term of the employment contract, that the employee works in a healthy, safe work environment, is insulated from bullying and harassment. And in this case, there were comments about how stupid she was. She was berated in front of managers and customers. There was some humiliating conduct on the part of the, humiliating treatment of Ms. Boucher by her supervisor or manager. She took the position she would not return to work until complaints were resolved. She never returned. The employer was criticized for the manner in which it handled the concerns raised by Boucher. The court also was critical of the fact that the manager or supervisor had not been properly disciplined or coached, or frankly dismissed for the kind of behavior he was involved in. The important part of this decision is the individual supervisor or manager was ordered to personally pay $100,000 for intentional infliction of mental suffering and $10,000 in punitive damages. There's a strong statement by the court that the behavior was completely offside. and because of it had on Boucher, she started to get ill. His behavior in forcing her out of the workplace warranted punishment and that rather large award of punitive damages. And that is, as far as punitive damages goes, a large award. I'll touch on this. I won't spend too much time on it. There are obligations under the criminal code. For example, section 217.1, that employers, people who are directing how other people do work or perform tasks, are under a legal duty to take reasonable steps to prevent bodily harm, I read that to include physical and mental, to that person or any other person arising from that work or task. So that is a code under the criminal a provision under the criminal legislation. As well, other relevant provisions in the criminal code, in their provisions dealing with assault, threats, extortion, criminal harassment, and I provided the relevant section numbers there. Generally speaking, unless the conduct is particularly egregious and intent is absolutely clear, I think these matters are more likely to be dealt with through civil avenues like the Human Rights Tribunal, the Workers' Compensation Board, or the courts, the civil system rather than the criminal system.
We're now going to turn to speak about employer responsibility and action, including more specificity about the specific proactive steps that an employer can take. So an employer is clearly responsible to provide a discrimination, bullying, and harassment-free work environment. And if not, they may be responsible for the consequences of that. Frontline managers and supervisors have to be aware, they have to be proactive. And where you are in a unionized environment, unions should be participating in this process. These are now legal obligations. The biggest challenge for employers is to ensure that policies are followed and consistently enforced and applied. So in terms of proactive groundwork, you start with your policy. And it should actively encourage early intervention. And your policies should be living documents. You're now obligated to have them under WorkSafe, but this is a very important communication tool within the workplace about your corporate values, about the expectations that you have for your employees, and also a avenue for the more serious concerns that employees have to be raised. So again, it's an extremely important tool. Workplace behavior and conduct competencies can also be included as part of your hiring decisions and in your performance reviews. So for example, your employment contracts can refer to the policies that are important for your organization. Your recruitment ads, they can identify the positive attributes that you're looking for. You're looking for people who are cooperative and collaborative and good to work with. As well, your performance reviews should be identifying and praising the competencies that you want to be encouraging. You should be engaging in regular and frequent feedback, and of course, modeling good behavior at all levels of the organization. This is a really important factor, especially for the most visible and high-profile roles within your organizations, because employees look to those people to be setting an example of the conduct that's expected within the organization. In terms of the training of employees, you definitely have to train them on conduct that's prohibited, that's required by WorkSafe. But go beyond that and train them on what's required and expected. Again, things like collaboration, teamwork, professionalism, and respect. Another very valuable skill for your employees to have is how to have difficult conversations, because they will need to happen from time to time in every workplace. That's something that my friend Richard, I know, has a lot of experience in terms of assisting with those difficult conversations. You also want to be training managers to recognize problematic behavior and to deal with it, to not stick their head in the sands when something challenging comes up in the workplace. Because again, referring to the conflict ladder, if you don't address it when it's a more at a lower step in the ladder, it's very likely going to escalate and become a more tangible problem for you. You want to engage in early identification of potential issues, paying attention to problematic behavior when it's witnessed by management, identify early warning signs of unhelpful behavior. So again, you're looking at distress, isolation, increased absence, changes in the demeanor of your employees. And you want to use those observations to engage people in conversation. That's the simplest and earliest step in all of this. A simple "how are you" sometimes is what's required of you. Is there anything I should know? Is something that you can ask your employees. And if issues arise, then you absolutely need to be taking steps to investigate, which we'll speak to in more detail. But once a complaint is received, the employer has to address it. It's now the law. And in doing that, there are informal and consent-based processes that can assist you, and there are formal investigation processes. Now, Richard is going to discuss some of the options other than or complementary to a formal investigation.
Thanks, Sandra. And complementary, I agree completely. The idea here is that organizations we've seen that manage their culture proactively, effectively, tend to be the ones that have given themselves a toolbox of very nuanced solutions. They provide themselves with a range of different processes that can't be brought to bear in appropriate circumstances. So they're not stuck with a one-size-fits-all kind of process response. The things that are useful to consider can be compared to what we typically call a workplace investigation. It's a kind of process which looks at what happened, who did it, what do we do to them, an investigation into fault and blame around allegations of wrongful behavior. Let's contrast that kind of a process with a number of slightly more nuanced tools. So the first one that we'll refer to here is workgroup assessment. Now, I don't want to pretend that these terms are in any way used universally. I'm going to use these terms and I'm going to try and define them in a way that will help you appreciate the differences that we see between different types of processes. By workgroup assessment here, we mean the focus is not on what happened, who did it, was it a breach of policy, what do we do? It's not an investigation into past acts. A workgroup assessment is an investigation into an inquiry into how a workgroup sees itself. How do they talk about themselves as a workgroup? The idea is to uncover the challenges and the opportunities for future improvement by identifying the language, the generative ideas that the people in the work group use to talk about themselves. This can be really, really useful when you've had lots of issues, lots of incidents, lots of people involved, but there's no hot conflict right now, where you're concerned that, gee, if we're not careful, we could end up back into a cycle of hot conflict. What can we do to avoid getting it? What can we do because we're worried that a next incident could bring us into a poisoned work group kind of complaint? Well, a work group assessment in the terms that we're talking about here are really useful. What we end up with from a work group assessment, which is a process of engaging with individuals through surveys, through one-on-one interviews, is an identification of the themes, the patterns that come up in how people talk about their work group. We get to make the work group accountable for what they say about themselves and each other by reflecting back in a report a composite of the words that they use to talk about their work group. The work group assessment builds dialogue because people see that their concerns are reflected back in a helpful way. It builds buy-in because the work group assessment doesn't position itself as being the fix. It positions itself as identifying what has to change, i.e. our perceptions about ourselves have to change. And it identifies the kinds of processes that will be useful going forward. So it creates a buy-in for a multi-level meta process going forward. We find workgroup assessments can be really, really useful. An alternative to that would be something like a systemic review. Now this comes up in organizations such as the Ombudsman of Ontario, which leverages this approach really effectively. What a systemic review is, it is a response to multiple cases, multiple incidents that have happened, multiple complaints, and it's a good response to an active poisoned workplace kind of complaint, where people are saying, look, this has happened, that's happened, and that's happened. What's going on with the systemic review is that an outsider is looking at what has happened, who did what. There is an allocation of responsibility. It's very much the external expert providing an opinion about who could have done what differently, but it's at the level of systems. What can we change systemically to avoid this happening again in the future? Again, a really helpful alternative to simply laying blame at the feet of one person and punishing them for inappropriate behavior. Another potential tool is a case review. When things have happened in the workplace, for instance, an employee has returned to work, there were concerns when the employee went off because of relationships in the work group. The employee was perhaps delayed in returning to work because of concerns over what it would be like back into the workplace. There was some incidents that occurred after the return to the workplace. A case review can be an appropriate response where we want to look at what happened and how do we avoid problems in the future? How do we fix this problem from a process perspective? So the case review is very much about asking, gee, how was the policy applied? How was it applied helpfully? How was it applied unhelpfully? And the solutions coming out of it are very much process-oriented. Another tool that can be useful is a process of workgroup conflict transformation, where we bring together a group of people to talk as a group about what's happened, how people have been affected, and what needs to happen to make things better. In a sense, a workgroup conflict transformation process is talking about the past for the purposes of bringing the conflict into the room and having the group be responsible for talking about what needs to change for the conflict to no longer be there. So another process that could be termed an investigation, and that we're looking at past events, but for a very different purpose, with a very different set of outcomes, than would be driven by traditional workplace investigation. Other potential process tools that you could find in a mature organization's toolbox would include things like a team charter process, having the group sit down, reflect on the past, to think about what we should be doing going forward in terms of our general behaviors with each other, so team charter coming out of that, interest-based mediation between a few individuals, arbitration, triage, screening for violence risk coming out of a situation, an assessment, actually assessing and managing violence risk coming out of situations. These would all be different tools that could supplement the traditional workplace investigation.
And now to talk a little bit about the traditional workplace investigation, because clearly with all of this legal regime around us, the requirements of a formal investigation can be really important in some cases. Calling it formal can cause some anxiety. We want to break that down a bit so that it is less overwhelming. So the law tells us that there's no specific standard of investigation that employers must follow. What's required will vary depending on the facts surrounding the employer, its policies, sophistication, experience, and the workplace. How the employer reacts is subject to judicial scrutiny. Its responsibilities do not give it a license to conduct an inept or unfair investigation or to behave in malicious, vindictive, or outrageous ways. So that comes out of a case involving home hardware stores and a Mr. Elgert, where they basically just slammed the entire investigation that did occur. That involved an alleged sexual harassment in the workplace, and the investigation went very badly. It wouldn't even pass the smell test, and here's why. The investigator didn't work at the store, but was friends with the boss. He was untrained, and he was extremely accusatory in the process. The allegation that was being investigated, it was by the boss's daughter. There was no written statement from the accused. There were no details provided to the accused about what he was being accused of. And so he didn't have an opportunity to fairly respond. And at the end of this investigation, which was basically conducted by a family friend, Mr. Coulter was from his employment. So in addition to the regular wrongful dismissal damages that arose, he was also awarded $30,000 in aggravated damages and $150,000 in punitive damages, which is one of the highest damages awards that I'm aware of. So there is a lot potentially at stake, but that really was a very poorly conducted investigation. You don't always have to meet the gold standard in order to meet your legal duty. So to break it down a little bit, what is an investigation? And essentially, it's just a fact-finding activity. Fact finder engages in a process to determine whether or not certain suspected or alleged events occurred. And one of the unique things about an investigation is that it allows you to collect pockets of information within your organization that are relevant and put it into one person's head so that they can make an informed. So issues or incidents require some degree of fact-finding to analyze, respond to, and manage the situation. There are a continuum of options in formal investigation. There's the informal, more conversation with employees, to a formal, lengthy engagement of an external, independent, neutral investigator. Sometimes a lawyer is appropriate. If you're relying on what comes out of the investigation to make an employment decision, you need to move up the continuum towards the more formal end of the spectrum. You want to make your decision more bulletproof. So you want to investigate in order to determine the truth because you want a fair process and to meet your legal duty. In terms of figuring out what happened, what's the truth of these allegations, things are often not as they seem. And the objective, of course, is to different versions of events. So that's the classic he said, she said. And sometimes you need to make a very difficult call to assess credibility. And you have to make the call on the basis of what you believe occurred. You cannot just throw your hands up and say that it's inconclusive. The responsibility of the employer is to make a difficult decision. Sometimes because of who the parties are that are involved with the investigation, and because there may be a need to make one of those credibility calls, it is entirely appropriate to have someone external to your organization be the one to make the credibility call and let them wear that decision. In terms of fairness, you're looking at procedural fairness, all of those things that were lacking for poor Mr. Elgert. And you want to build a case before taking disciplinary action and avoid arbitrary or unfair decisions. Of course, then, as well, in terms of your legal duties, procedural fairness again, building your due diligence defense so that you can manage any litigation exposure, engaging in the duty of good faith, addressing the potential of human rights complaints for failure to properly investigate, and of course now the very broad arena in which WorkSafe can interject themselves. In terms of triggers and what could trigger an investigation, you're looking for suspicion, you're looking for allegations, specific ones. You may get internal or external complaints. You may get anonymous complaints, the brown paper envelope that slid under your door, and observed behavior. You ignore any of these potential triggers at your peril. In terms of observed behavior, there are the red flags, and really a lot of this often comes up down to a gut check if you're observing this type of conduct. You may observe angry outbursts, people being avoided, high turnover, etc. And these things can trigger your need, or at least it will be a benefit to you if you take steps to address these observed behaviors. So basically you're asking yourself, if the matter that's being complained of is true, does it fall within one or more of these areas? And it's the areas that we've been talking about. Is there a human rights prohibited ground that's engaged? Is there non-human rights-based harassment or bullying? And is there the possibility of a more systemic matter in a poisoned work environment? Now it's really important as part of your response that you're moving very quickly. And that allows you to avoid a formal complaint if possible, to do something before a formal complaint needs to be made. And it gives you the chance to resolve it before something goes viral within your organization. And we all know that those stereotypes about conversations that take place at the water cooler, those are really damaging sometimes in places of employment. And you want to be able to effectively address the problem. You also want to avoid a cold trail. Memories fade, documents go missing, and situations evolve. So you want to act quickly so that you can capture the best information possible in coming to your decision. You need to consider the legal framework that's involved, the applicable legislation, which we've talked about, your own policies and procedures, collective agreement obligations if you're in a unionized environment. When you do become aware of an issue, you want to clarify the allegations and identify all of the possible issues, recognizing that sometimes the person who's putting their hand up and complaining may not be aware of all of their rights. That's your responsibility as the employer to provide a more fulsome response. You also want to be determining how far back you're going to be looking and whether there are other complainants potentially or victims of the alleged conduct. Sometimes the person complaining to you is not the person who is the target of the conduct. You'll want to consider whether an investigation is required at all. Sometimes it is far more appropriate if you're before a formal complaint in particular and obligations aren't triggered under your policy to use one of the other of the items in the menu, such as that Richard had described. You need to consider whether you want to involve your legal counsel and get advice at the start, whether you might require some legal advice or privilege in your fact-finding process as well. It can be a very valuable tool. You need to think about who should conduct the investigation. I have some slides that address that you can review. And how and when you will communicate with management about the issue that's arisen. Some organizations, as you know, have people at the top who want to know every detail of something that could spin into a bad situation. Others will want you to manage it and only come to them at a later time. You want to establish a time frame, which is often very difficult when you don't know the full scope at the start of a complaint process, and whether or not the union should be involved. Consider how you're going to organize all of the information that comes to you, what the scope will be, whether you're looking at legal violations or company policy, how much information is enough, and what it is you're looking for. Now this is important. Just because a complainant doesn't want to investigate doesn't mean you're not obligated or shouldn't do an investigation. Employees are obligated to participate and to cooperate, and your policy should outline that obligation. You're going to need to identify potential witnesses. Ask yourself critically who may have some insight into this that you should be speaking to, and you add to that list as necessary as your investigation proceeds. I'll often tell people that I'm interviewing that I'd like their input about who they think I should talk to, but I make it very clear that I'm the one who will make the decision about who the participants will be. You need to beware of hearsay, so think very carefully about who actually witnessed something. And sometimes that means chasing down the rumors. So someone will tell you, I heard John say X. And then you need to go to John to find out what actually John observed. And sometimes you have to chase that quite far down the rabbit hole, and the information at the end of it, just like a game of telephone, may be very different from what started, but you can't rely on the initial information you got if it was hearsay. Other persons who may have relevant evidence, think about this broadly within your organization. Do you need to be talking to the computer technicians? Do you need to talk to your internal security personnel? Might former employees have something relevant to say? You need to identify and gather relevant documents, which will be different depending on the fact pattern you're looking at. And you need to address immediate issues. This is really important. Think about if there are potential safety concerns. Is there a reason to believe that the alleged wrongdoer can be endangered to the complainant, to the employer, to property, or to him or herself? You might need to remove someone from the workplace, so consider whether you need to be looking at suspending someone with or without pay, depending on the circumstances. Whether you can just simply adjust schedules until you have a chance to really look into a matter. Do you need to give warnings about retaliation in the workplace? That should also be in your policies. Putting an end to office gossip. Again, whether you're educating management or your boss about the circumstances. Considering any public relations issues that could arise. And whether you need to actually involve internal or external security to address your matter. A couple slides on whether you would be looking at an internal or an external investigator. Sometimes that's a very intuitive decision, but there are some factors there that you can look at that might assist you. And then you're looking at actually preparing for the investigation, and here are some steps that you would take to do that. I'm going to pass over to James, who's going to talk about outcomes of investigations.
Thank you, Sandra. So here is what I seek to cover in the next few minutes. I won't go over all of the slides in detail. You have the materials. We've provided them to you for the sake of being complete. I'll begin with the topic of written reports. These are important. They reflect on the employer and the kind of organization the employer runs or operates. If there are deficiencies in the reports, think back to the Albert case where there's no defined legal standard for the kind of investigation an employer engages or carries out, but a shabbily prepared report with problems in it, with inconsistencies, could well lead to liability if the ultimate decision of the employer is wrong. Remember that report can be presented as evidence to a court or other decision maker, technically hearsay, but it could be introduced to illustrate the point about inadequate or improper investigation. So notes should be complete, structured, well-drafted, balanced, and fair. What should your written report look like? Here is a skeleton of what the report should contain. Scope of mandate, nature of complaint allegations, dates and other particulars, individuals involved, witnesses, when, how many times they were interviewed, list of evidence, applicable law, policies, legislation, collective agreement provisions, summary of evidence, factual findings and credibility determinations, conclusions, outstanding issues, recommendations. Now, these are the sorts of recommendations which could come out of a report, which could be the product of a report. Disciplinary action, training, counseling, mediation, demotion or transfer, caution with that, particularly in a non-union environment, but also in a union environment. Apology, notification to the police. These are the kinds of things Richard and Sandra spoke about. Prevention of the incident reoccurring in the future. I mean, we're not interested in dealing with symptoms. We're interested in dealing with the root cause of the problem. So training, increased training, better training, policies, procedures, better published, better known, understood, and applied, consistently applied, improvement of security systems, implementation of better checks and balances in the system. Think about, for example, accounting. So action has to be taken, of course, following the issuance of the report. It can be circulated among key decision makers. Careful about unintentionally waiving privilege over the report if it was prepared by a lawyer, if you wish to be relying on it as privileged. Communicate the outcome to the complainant and the wrongdoer. Caution there. The complainant, for example, has no right to know what discipline was meted out to the respondent. You want to also make it clear to the participants in the process there is zero tolerance for retaliation or reprisal. Presumably that would have been done in the course of the investigation, but there should be a reminder on the tail end. And then there's some basic principles there regarding the level of discipline which should be issued. These are responses which can follow an investigation and the issuance of the report. I've touched on some of these already, but you have a list there before you. Remember that you're operating in the area of labor relations, particularly in the union environment. Be mindful of the progressive discipline regime, but also in the non-union environment, you want to make sure your response is a contextual and appropriate response. You will want to take account of mitigating, aggravating circumstances in both union and non-union environments. To Richard and Sandra's point, you're not imposing discipline in lieu of taking steps to address the root cause. The discipline is basically an adjunct to the process. You want to deal with the root cause. Consequences of a good investigation. This is the due diligence defense we spoke of earlier. Due diligence is often the only defense an employer has to happenings in its workplace. You want to demonstrate the employer exercised due diligence to prevent reoccurrence of the incident. You want to exercise due diligence to mitigate the effect of any unlawful, inappropriate conduct. And as long as the employer is behaving in good faith in accordance with policy, doing what it can to be a good employer, it will have a good defense, possibly a full defense to allegations of turning a blind eye. There are the things an employer will want to do in trying to demonstrate that it has taken steps in due diligence. You must have appropriate mechanisms in place to deal with complaints, deal with complaints with alacrity, efficiently, expeditiously, take complaints seriously, ensure you're providing a healthy work environment, making sure that the complainant is informed, respecting privacy, of course, of the employer's response. Before the Human Rights Tribunal, complaints are often dismissed where due diligence is properly exercised. I'm not going to deal with this case. You have it in the materials, but this is a case where the employer did the right thing and the tribunal applauded the employer and dismissed the complaint quite quickly. This is another case, Cobble Hill Grocery, in which the employer's efforts to do things properly paid off and the employer reaped the benefits. Again, given time restraints, I'm not going to cover the case. Consequences of a flawed investigation. You see at the bottom of each slide the damages which were issued in each case. This is the Vernon case, and there's a summary of the facts. Here is the Elgert case, which Sandra spoke to. Again, summaries of the damages which were awarded, and this Georgian Cowichan Tribes case. These are some pointers for dealing with investigations properly. And not going to take time to review them, but essentially it all boils down to fairness and principles of natural justice. You're not jumping to conclusions, and you're doing things in a balanced, impartial, and appropriate way. Confidentiality cannot be assured absolutely. People can be told that all reasonable steps will be taken to guard confidentiality. Information is disclosed on a need-to-know basis, but essentially witness statements and other investigation-related documents may be ordered produced in the context of a legal proceeding. And as a matter of natural justice, allegations leveled against the respondent by a complainant will be put to the respondent for his or her response. That's a matter of fairness. And employees can be reminded in the same way about confidentiality and the importance of preserving that in the same way they are warned about retaliation and reprisal. Richard, I'll hand it to you quickly. I know we're running short of time, but you want to speak to the slide, I believe.
Excellent. Thanks, James. And I will. I'll just mention one simple point, which is coming out of an investigation, investigations themselves tend not to address the underlying situation that gave rise to the initial incident. Investigations themselves can actually intensify the conflict dynamics that typically give rise to complaints that lead to investigations. And so it can be really helpful just to distinguish as you come out of an investigation as to whether in all of the circumstances, are you really dealing with a situation where people just weren't clear in the first place about the rules, about how to ask, and how to act with each other? Because if that's the case, then preparing people to go back to work with each other after an investigation may simply be useful to review the rules with people. In other words, it's enough, it's due diligence to simply review the rules, get people on the same page, and expect them to be able to behave well with each other once they're back together. The alternative scenario is, hey, this was never about the fact we weren't on the same page with the rules. This was about the fact we didn't like each other. We weren't prepared to follow the rules because of that. Now that the investigation's over, just to send us back to the work group and anticipate that things are going to be different because there's an investigation, that may be a problematic assumption. So there can be other processes to engage in if the underlying problem was conflict in the first place. That's all we need to say at this point.
I will take a moment just to conclude here. I'd like to thank everybody warmly for joining us today. We dealt with a couple of questions which came up during the course of the presentation. Please do feel free to reach out to Sandra, Richard, or myself if you have any follow-up questions. We've provided all of our contact information here, and we'd be happy to address any question you might have. Thanks again for joining us.
Thank you.
Bye.